One biased chairman, one manipulated shareholder meeting, one improper ruling during voting, and suddenly an entire corporate decision involving crores can fall into governance controversy, shareholder litigation, and regulatory scrutiny. In many corporate battles, the real control over a meeting is not merely about voting power. It is about who controls the chair. The chairman of a general meeting can influence discussion flow, procedural rulings, voting conduct, adjournment handling, and governance discipline. Section 104 of the Companies Act 2013 may appear like a small procedural provision, but in actual corporate warfare and governance practice, the chairmanship of meetings can determine the legitimacy, stability, and credibility of corporate decision making itself. Welcome to Corporate and Securities Law Compass, navigating law with clarity. Today we are discussing one of the most practically significant governance provisions connected with shareholder meetings under the Companies Act 2013. Section 104 dealing with chairmen of meetings. At first glance, many professionals assume this provision merely identifies who presides over a meeting. But in actual corporate governance, the chairman of a meeting plays an extraordinarily powerful procedural and strategic role. The chairman controls order. The chairman regulates participation. The chairman supervises voting. The chairman decides procedural disputes. The chairman ensures meeting discipline. And in contested governance situations, the chairman often becomes the focal point of litigation itself. To understand the true importance of Section 104, we must first understand the philosophy behind corporate meetings. Meetings are not casual gatherings. They are formal legal proceedings through which companies exercise collective decision-making authority. Without procedural control, meetings may descend into chaos, manipulation, or governance paralysis. Section 104, therefore, establishes leadership structure within shareholder meetings. The provision states that unless articles provide otherwise, the chairman of the board shall preside as chairman at every general meeting of the company. This immediately creates an important relationship between articles of association and statutory governance structure. The articles may prescribe alternative procedures, but in absence of such provisions, the board chairman ordinarily presides. This reflects practical governance logic. The board chairman generally possesses organizational familiarity, governance experience, and procedural authority. However, Section 104 also recognizes practical realities where board chairman may be absent, unwilling, or unavailable. If the chairman of the board is not present within 15 minutes after scheduled meeting time or is unwilling to act, directors present shall elect one among themselves to act as chairman. This 15-minute concept becomes practically important. Corporate law balances procedural discipline with operational practicality. Meetings cannot remain indefinitely leaderless. Another major governance insight emerges here. Section 104 protects continuity of shareholder meetings. Even if designated leadership fails, alternative mechanisms exist to preserve governance functionality. Suppose no director is willing or available to preside. The members personally present shall elect one among themselves to act as chairman by show of hands. This provision is deeply democratic. Ultimately, shareholder meetings belong to members. Where management leadership fails, members themselves may choose procedural leadership. This reinforces the constitutional nature of shareholder democracy. Another important hidden governance concept under Section 104 is neutrality. Though the chairman often comes from management or promoter groups, the role itself carries fiduciary and procedural fairness expectations. A biased or manipulative chairman creates major governance risk. This becomes extremely important in disputed meetings. Practical examples help illustrate governance realities better. Imagine a listed company facing shareholder revolt against promoter controlled management. Institutional investors oppose certain resolutions. The chairman selectively permits discussions supporting management but suppresses dissenting shareholder participation. Immediately, allegations of procedural unfairness arise. Litigation risk escalates. This demonstrates why chairmanship is far more than ceremonial. Another practical scenario may involve family owned companies. Suppose promoter factions are fighting over control. During shareholder meeting, disputes emerge regarding voting rights, speaking opportunities, and procedural rulings. The chairman's conduct may influence legitimacy perception significantly. In such situations, neutrality becomes critically important. Another hidden practical concept involves powers of chairman. Though Section 104 primarily addresses appointment, broader governance practice recognizes multiple procedural powers. The chairman maintains order during meetings. The chairman ensures business proceeds according to agenda. The chairman supervises voting procedures. The chairman addresses procedural objections. The chairman may regulate speaking opportunities reasonably. However, these powers are not absolute. They must be exercised fairly, lawfully, and in good faith. Courts and tribunals frequently examine whether chairman acted oppressively or manipulatively. Another important governance insight relates to adjournment powers. The chairman often exercises procedural authority regarding adjournment management. Improper adjournments frequently trigger litigation. For example, strategic adjournment to manipulate attendance patterns may create governance challenges. This is why procedural fairness matters enormously. Another practical issue involves quorum verification. Before assuming effective conduct of proceedings, the chairman should ensure quorum exists under Section 103. Failure to verify quorum properly may invalidate proceedings later. Experienced company secretaries therefore coordinate closely with chairmen before commencement. The role of company secretary under Section 104 becomes extremely significant. The CS often acts as procedural advisor, assisting the chairman regarding legal compliance, voting procedures, quorum issues, and governance discipline. A competent CS can prevent serious procedural mistakes during meetings. Weak secretarial support often results in governance complications. Another major practical area involves voting disputes. The chairman frequently supervises voting mechanisms, including show of hands, poll procedures, and e-voting coordination. Improper handling of voting creates severe litigation risk. Listed companies face particularly high governance scrutiny. Institutional investors and proxy advisory firms closely monitor shareholder meeting conduct. Modern governance standards increasingly emphasize fair participation and transparent procedural management. The chairman's behavior during meetings directly influences investor confidence. Another hidden governance insight involves perception management. Even technically lawful conduct may create governance distrust if shareholders perceive procedural bias. Good chairmen therefore combine authority with fairness and professionalism. This becomes especially important during controversial resolutions involving mergers, preferential allotments, related party transactions, or director removals. Another practical governance challenge arises where multiple groups claim chairmanship rights. In disputed companies, rival factions sometimes attempt parallel meetings or competing chairmanship claims. Such situations frequently escalate into tribunal proceedings. Section 104 therefore becomes strategically important during corporate control disputes. The relationship between Articles of Association and Section 104 is commercially significant. Many companies prescribe detailed chairmanship procedures through articles. Joint venture companies may create investor protective governance clauses. Private equity investors sometimes negotiate procedural rights regarding meeting conduct. Violation of such governance arrangements may trigger contractual disputes and oppression allegations. Another important practical issue involves proxies and authorized representatives. The chairman should ensure proper verification before recognizing voting participation. Mistakes here may compromise meeting validity. This becomes particularly sensitive during high-stakes shareholder disputes. Another governance insight relates to shareholder participation culture. Strong chairmen encourage orderly discussion and balanced participation. Weak or biased chairmen create hostile governance environments. Corporate culture often becomes visible during meeting conduct itself. Another hidden examination-oriented concept involves distinction between chairman of board and chairman of meeting. Students frequently confuse both. The chairman of board ordinarily presides if present and willing. But where circumstances differ, meeting-specific election procedures apply. This distinction is fundamentally important. Another practical governance issue involves electronic participation and hybrid meetings. Modern corporate governance increasingly incorporates digital participation systems. Chairmen must manage technological coordination, electronic voting supervision, and remote participation fairness. This creates evolving governance challenges. SEBI-LODR obligations and shareholder participation frameworks also influence governance expectations for listed companies. Another major practical concept involves procedural objections. Shareholders frequently raise objections during contentious meetings regarding voting rights, agenda scope, quorum validity, or disclosure sufficiency. The chairman's handling of such objections becomes critically important. Arbitrary dismissal of legitimate concerns may strengthen future litigation. This demonstrates why governance professionalism matters enormously. Another hidden practical issue involves minute drafting. Minutes should accurately reflect procedural developments, objections, rulings, and voting outcomes. The chairman typically signs minutes, thereby authenticating proceedings. Poorly documented minutes weaken governance defensibility. Secretarial Standard 2 on general meetings provides detailed procedural guidance relevant to chairmen. Experienced governance professionals rely heavily upon SS2 for meeting discipline and litigation defensibility. Secretarial auditors also review procedural compliance carefully. Another important governance insight relates to fiduciary expectations. Though the chairman may represent management, the role itself carries broader responsibility toward fairness of proceedings. Corporate democracy loses legitimacy where procedural leadership becomes oppressive. This principle increasingly influences judicial thinking. Another practical area involves tribunal intervention. Under Sections 97 and 98, tribunals may appoint or direct specific chairmanship arrangements in disputed governance situations. This reflects recognition that procedural neutrality may become essential during severe conflicts. Another hidden governance concept involves strategic meeting management. Experienced governance professionals understand that procedural handling influences shareholder confidence significantly. Transparent meetings build trust. Manipulative meetings create suspicion. And in modern corporate governance, perception often influences market credibility. Another practical due diligence insight is that investors increasingly review historical meeting conduct and governance culture. Repeated shareholder disputes, procedural controversies, and litigation involving meetings create governance red flags. Banks, private equity funds, and institutional investors closely examine governance stability. Another major litigation area involves oppression and mismanagement proceedings under Sections 241 and 242. Allegations frequently include biased meeting conduct, suppression of shareholder participation, and manipulative procedural rulings. Chairman behavior, therefore, becomes legally significant. The role of advocates becomes extremely important during contentious meetings and governance disputes. Chartered accountants contribute particularly where financial resolutions and voting implications intersect. Cost. Accountants may become relevant in operational restructuring approvals. Company secretaries remain central governance coordinators, ensuring procedural legality throughout. Another important practical governance lesson from professional experience is preparation. Chairmen should review agenda carefully, understand voting implications, anticipate shareholder concerns, and coordinate with compliance professionals before meetings. Poor preparation creates governance risk. Another hidden practical concept involves emotional management. Contentious meetings often involve aggressive shareholder interactions. An effective chairman maintains procedural calm and lawful discipline without appearing suppressive. This balance is extremely difficult but critically important. Practical governance advice from professional experience is therefore invaluable. Never treat chairmanship casually. Never ignore procedural objections carelessly. Never manipulate voting conduct. Never suppress shareholder participation unfairly. Never overlook quorum verification. And never assume meeting control exists merely because management controls the board. Because under corporate governance law, procedural fairness often determines whether decisions survive judicial scrutiny. Ultimately, Section 104 represents much more than a procedural appointment provision. It establishes the leadership structure necessary for lawful and orderly shareholder democracy. It protects governance continuity. It supports procedural discipline. It balances authority with fairness. It strengthens meeting legitimacy. And it ensures that corporate decision making occurs within structured and accountable procedural frameworks. That is why every company secretary, advocate, chartered accountant, director, investor, and governance professional must deeply understand Section 104 of the Companies Act 2013. Because in real corporate governance battles, control over the chair often becomes control over the meeting itself, and control over the meeting may ultimately influence control over the company. If you like this video, kindly like, subscribe, and hit the bell icon for latest notifications from Corporate and Securities Law Compass. Like, share, comment, subscribe. Disclaimer: viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, Seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India, ICSI, and any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information, UPSI, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations, 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.